Begin the recording of the meeting. I will now take the sediment for this meeting of the Planning Local Review Body held on the 2nd of October 2023. The following members, actually I've got apologies from Councillor Alec Allison, Councillors Jerry Convery, Colin Dewar and Gladys Ferguson Miller are present. Councillor Elise Frame is not present. Councillor Mark Horsford is present. I have apologies from Councillor Leslie MacDonald. Councillors Richard Nelson and Norman Ray are present. I have apologies from Councillor Graham Scott, and Councillor Maureen Devlin is attending as a substitute. Thank you, and I'll pass you back to the Chair for today's business.
Thank you, Stuart. We will then move into the agenda items. Agenda item number 1, any declarations of interest? No declarations of interest. Agenda item number 2 is the minutes of the previous meeting, which is in pages 3 to 6. These are submitted for approval as a correct record. I will agree.
Second it.
Anyone otherwise minded? All agreed. Thank you. Agenda item number 3 is a review of case in respect of planning application P230413, which is in pages 7 to 84 in your pack. The item before us today is a notice of review from Andrew Megginson Architecture on behalf of Mr and Mrs Kirkina. The applicant is asking the PLRB to review the planning officer's determination to refuse an application for planning permission for an ancillary accommodation to rear garden at 67 School Road, Sandford and Straven. Firstly, as noted in section 6 of the report on page 9 of the papers, the statement of observation from the planning officer on the notice of review was not received within the required 14-day period, and as such has not been included in the papers. Whilst late, the statement has been received, and I will now ask the legal advisor to comment on the status of this representation and the options available to the review body before we proceed to the review itself. Monica?
Thank you, Chair. As Councillor Nelson has stated, the statement of observations from the Planning Authority is not included in today's papers. South Lanarkshire Council's approved guidance in relation to the process of conducting a local review requires that the planning officials be notified of a review and given 14 days to comment. In this case, the planning officer's submission was received out with the 14 days allowed. The applicant's agent has objected to the late submission being included in the review and has declined to comment on the observations as he considers they should not be admitted to process. The first decision for the PLRB today, therefore, is whether to allow the late submission. As PLRB members will be aware, Section 25 of the Town and Country Planning Scotland Act 1997 requires planning applications to be determined in accordance with the development plan unless material considerations indicate otherwise. In making that determination, all relevant planning matters must be taken into account. Consequently, the PLRB has a discretion to accept the late submission if they consider it will raise relevant planning considerations. If the PLRB were to allow the late submission, however, I would advise that the applicant must be given the opportunity to comment on the submission. This would inevitably mean that the review could not be conducted today and there would require to be further procedure, whether that be in writing or in the form of a hearing. That would be for the PLRB to determine, but there would have to be further procedure to allow the applicant to comment on the late submission. In summary, the PLRB has effectively 2 options. 1, to not allow the late submission from the Planning Authority and continue to conduct the review today. Secondly, the PLRB could allow the late submission and require the applicant to comment on the late submission by way of writing, possibly giving at least a period of 14 days for such a response. If this were the preferred course of action, the review would require to be continued to allow this further information to be received. Thank you, Chair.
Thank you, Monica. Taking account of what's in our papers, and we've just heard from the legal advisor, we have to decide if they in fact contain sufficient information for us to determine the review, or if we need more of that information, a hearing or a visit to the site. Are we all happy to proceed? I will move that we proceed.
I second it.
Okay, I will, no further questions or comments on that, so I will then ask the planning advisor to describe the background to this request for a review to the members. James.
Thank you, Chair. This local review relates to the refusal of an application for planning permission for ancillary accommodation at 67 School Road, Straven. The site is located within the settlement boundary of Straven as defined in the adopted South Lanarkshire Local Development Plan 2. The application site is an end terrace dwelling house with garden ground to the rear. The ancillary accommodation is to be located to the rear of the back garden and comprises a living area with kitchen and a bedroom with ensuite bathroom. The front wall of the proposal would be approximately 18.9 metres from the rear wall of the existing dwelling house. As noted in the photos on pages 31 and 32 of the papers, the rear garden slopes steeply upwards from the house, with the majority of the garden being elevated from the dwelling house. Again, as noted in the agenda papers, there were no letters of representation received following advertisement of the application, and no consultations were required given the nature and scale of the proposals. Since its adoption in February, National Planning Framework 4, or NPF 4 for short, now forms part of the development plan, alongside the adopted South Lanarkshire Local Development Plan 2. Section 24(3) of the 1997 Planning Act confirms that if there is an inconsistency between NPF 4 policies and a local development plan which was adopted before the 13th of February 2023, then the policies in NPF 4 will prevail. The current South Lanarkshire Local Development Plan was adopted in 2021, and therefore NPF 4 would prevail should there be inconsistencies between policies. Therefore, in assessing this local review, the local review body are respectfully requested to consider the following relevant policies of NPF 4 and the South Lanarkshire Local Development Plan 2, which are Policy G of NPF 4 Policy 16, which states that householder development will be supported where they do not have a detrimental impact on the character or environmental quality of the home and the surrounding area in terms of size, design and materials, and where they do not have a detrimental effect on neighbouring properties in terms of physical impact, overshadowing or overlooking. In terms of the adopted South Lanarkshire Local Development Plan 2, the relevant policies are Policy 3, General Urban Areas and Settlements, which states that residential developments on appropriate sites will generally be acceptable. Particular consideration will be given to likely impacts on the amenity of the area. Developments which would be detrimental to the amenity of residents and the wider community or to the character of the surrounding area will not be permitted. Then Policy 5, Development Management and Placemaking, which states that in order to ensure development takes account of the principles of sustainable development, all proposals require to be well designed and integrated with the local area. Proposals should have no unacceptable significant adverse impacts on the local community and the environment. Then Policy DM2, House Extensions and Alterations, which states house extensions and alterations will be considered favourably where it can be demonstrated that the proposal complies with the following criteria. The siting, form, scale, design and materials respect the character of the existing dwelling and the wider area. Within this context, high quality, innovative design will be encouraged where it complements the character of the building and its surroundings. 2, it does not dominate or overwhelm the existing dwelling, neighbouring properties or street scene in terms of size, scale or height. 3, it does not significantly adversely affect adjacent properties in terms of overlooking or loss of privacy, daylight or sunlight. And finally, Policy DM5, Extended Family Accommodation, which states the formation of separate family accommodation through either the extension of existing dwellings, the conversion of an outbuilding within the curtilage of the donor house, or formation of alternative temporary accommodation such as a chalet or lodge, shall be acceptable where all of the following criteria can be met. 1, a detailed justification will require to be submitted to demonstrate the need for the development and the form and scale of the proposed accommodation. 2, adequate garden ground, access, parking and turning facilities continue to be provided within the site. 3, no harm to the amenity of neighbouring properties through loss of privacy, overlooking or overshadowing will occur. 4, the proposals do not harm the amenity or the character of the surrounding area. And 5, The proposal takes account of any supporting planning guidance prepared by the Council where relevant to the proposal. Where proposals for the formation of a family annex are acceptable, any planning consent will be subject to imposition of a tying condition. This will stipulate that the extension or converted building shall be used solely as accommodation ancillary to the main dwelling house. This is to ensure that the family annex is not occupied, let or sold as a separate dwelling unit, where otherwise the formation of an additional dwelling would be unacceptable due to a lack of garden ground, insufficient parking or unsuitable access. In the case of temporary accommodation, this would also be limited by planning condition relating to timescales and purpose for which it is required. It is these policies that provide the development plan basis for considering the application. Thank you, Chair.
Thank you, James. As members will now be aware, from the 13th of February, I'll just read that again. Sorry, apologies. Can we just open for any questions or comments? No questions or comments? Can I just summarise the points made? The application is for ancillary living accommodation within the rear garden of a dwelling house. The adopted South Lanarkshire Local Development Plan 2 identifies the site as being within the settlement boundary of Straven. If we consider that there is no valid policy justification to support the proposed extension and alterations at this location, and it would not accord with Policy 16 of NPF 4 and Policy 3, 5, DM2 and DM5 of the adopted South Lanarkshire Local Development Plan 2, permission can be refused. Or if we consider that there is adequate justification for the proposed rear extension and alterations, we could grant planning permission subject to conditions. Our options here are uphold, reverse, vary the planning decision. I'm going to invite decisions and the reasons for these decisions. There's no motions or amendments. Are members minded then to uphold the officer's decision to refuse planning permission? Are we all agreed? Agreed. Is anyone otherwise minded? Okay, therefore, the decision of the PLRB is to refuse planning permission as we are satisfied that the proposed development will be contrary to Policy 16 of MPF 4 and Policy 3, 5, DM2 and DM5 of the adopted South Lanarkshire Local Development Plan 2. The next stage is that a written decision notice will be issued by the PLRB and issued within 28 days. Agenda item number 4, I have no item of urgent business other than to thank James for his support to this committee. James is leaving on Friday, and I'm sure we all wish James a good farewell in his new role. And James, thank you from all of us here for your continued work to the PLRB, and I wish you all the success in the future. And I'm sure we all do the same here as well. Thank you. I hope you all enjoy the rest of your day. I'll ask Stuart just to stop recording the meeting. Thank you.